Well, good morning. I want to thank everyone for taking the time to be able to be here, and this hearing will come to order. I would like to be able to thank our witnesses for taking time away from your full-time jobs for this important hearing. We do look forward to your testimony. As we celebrate World Trade Month, this is an ideal time to review our trade policy initiatives and the effects on small businesses here in the United States. Currently, there are a variety of trade policy initiatives in the pipeline, including ongoing negotiations with the Trans-Pacific Partnership, the Transatlantic Trade and Investment Partnerships, and the possible renewal of Trade Promotion Authority. These initiatives will directly or indirectly affect the way small firms compete and operate in the global economy. Exports are a significant contributor to the United States economy, helping support millions of good-paying jobs in trade and competing industries. In 2013, the United States exported nearly $2.3 trillion in goods and services, an all-time high. Small businesses account for a substantial share of this value. According to statistics from the United States Census Bureau, approximately 97% of exporting businesses are small and medium-sized businesses. While legal trade can confer many benefits for small businesses and the economy, the opposite is true when foreign nations and companies refuse to play by the established rules. Particularly unfair and predatory trade practices like dumping and intellectual property theft can result in substantial monetary harm to small businesses in trade-competing industries. In addition, an inability to be able to protect your intellectual property rights can stifle the innovation necessary to come up with further technological advances. Remedies exist for small businesses to fight these unfair trade practices. Unfortunately, in too many cases, the cost and complexity involved in fighting unfair foreign trade practices are beyond the means of most small businesses. A recent report from the Government Accountability Office highlighted some of these challenges, noting that the cost of pursuing anti-dumping and countervailing duty cases at between $1 and $2 million. I have no doubt that the U.S. small businesses can compete with any company in the world. As we review the current trade agenda, we need to take a dual approach of improving coordination of domestic federal agencies and strengthening our enforcement against unfair trade practices to ensure a level playing field for all small businesses. Again, I want to thank our witnesses for participating in today's hearing, and I'd now like to recognize our ranking member for his opening statement. Mr. Murphy.
Thank you, Mr. Chairman. I want to thank you for putting this all together today, and thank you for calling this very important hearing. I also want to thank the witnesses for being here and testifying on this very important issue. I'm sure we all wish that votes were not interfering this morning, but I'm looking forward to listening to your comments and understanding how unfair trade practices are hurting American small businesses and what we can do to alleviate these problems. Reducing trade barriers and expanding free movement of capital, goods, and services has transformed the U.S. economy and enabled the rise of a global economy that has created new markets and expanded American access to emerging markets. The resiliency of small businesses has accounted for 2/3 of all new jobs created. In 2011 alone, small businesses accounted for 97% of the total number of U.S. exports. Over 200,000 small businesses are sending American products to every corner of the globe, reducing our trade deficit to the lowest levels in a decade and spurring a revival in the U.S. manufacturing sector. Although small firms have increased exporting in recent years, they still face several challenges accessing foreign markets. The main barrier seems to be the lack of information and an unclear understanding of where to start. Nearly half of small business exports send a minimum of 3 months to nearly 10% of their annual operating revenue just preparing to export. The Export-Import Bank and the Small Business Administration have been vital to promoting the success of these companies by providing needed capital, one-on-one counseling, and access to foreign markets. I'm hopeful that ideological crusades do not get in the way of reauthorizing EXIM so that small business owners can continue to be at the forefront of global trade. While the federal government offers numerous trade promotion programs, more collaboration and outreach is necessary to ensure these services are accessible by the firms that need them the most. Unfair trade practices remain a major concern of U.S. workers as America debates new trade liberalization agreements in TPP, TTIP, and TISA. These agreements have the potential to open new avenues for exporting around the world by lowering tariffs and harmonizing regulations. The benefits are not without costs, however, and some provisions remain controversial. It is our job here in Congress to promote U.S. interests and see that our trade objectives are met. As negotiations progress, we will be watching closely. Issues such as currency manipulation, unacceptable labor and environmental standards, anti-competitive state-sponsored subsidies, dumping of goods in the U.S. below market value, and intellectual property rights violations are all serious problems that need to be addressed to preserve American small business competitiveness in the global stage. Hopefully, this hearing will provide insight to addressing these obstacles. Again, I want to thank the Chairman, I want to thank the witnesses, and I apologize that votes are going to take us away this morning. Thank you.
Thank you, Mr. Murphy. If committee members have an opening statement prepared, I ask that they submit it for the record. I'd like to be able to take a moment to be able to explain our timing lights for you. Each of you will have 5 minutes to be able to deliver your testimony. The light will start out as green. When you have 1 minute remaining, the light will turn yellow, and finally, at the end of your 5 minutes, it will turn red. I'd ask that you would try to adhere to the time limit if you can, and we'll let you summarize at that point. I'd now like to yield to our colleague, Mr. Bacchus, so that he may introduce our first witness.
I thank you, Chairman Tipton, also Ranking Member Murphy, for allowing me this privilege. Milton Magnus is a spokesman for both his company and the American Wire Products Association. He serves as their president. He's president of M&B Metal Products in Leeds, Alabama. He's the third leading job supplier or employer in that town of 12,000 people. I can't imagine Leeds without M&B hangers. And what they do is they produce coat hangers. You'll find that he's very knowledgeable witness about the impact of unfair and illegal trade practices and their devastating effect on small and medium-sized businesses that are really the backbone of our economy, supply 70% of our jobs. He has just about been put out of business by illegal dumping from China. That's the bottom line. Most of his competitors in the United States are out of business. And the incredible thing is they put them out of business, American companies, and then they buy their equipment and sometimes take it to China or just put it out of production. They buy it because they've eliminated most of the domestic production. Our office has worked with him for years. He has hired private investigators. He's documented with pictures, transshipping, dumping, where they actually put on a box that it's made in Vietnam and they ship it directly from China. He's had pictures of where they claim the production is in Vietnam, and all it is a small shack with absolutely nothing there. And let me say this, I've always voted for free trade. I've been an advocate of free trade, but this sort of foolishness turns people against fair trade, and it makes people resist it. And if we're going to continue to be a trading nation and negotiate these agreements, which I think we have to, the bottom line is we have to enforce them. Some of our competitors don't play by the rules, don't even make a pretense of doing it. And some of us, I think, who've been the advocates of free trade, with some countries, unless they change their ways, I'm afraid we just can't. There's just no way to promote trade with people who don't play by the rules. So thank you again. Mr. Murphy and I are both going back to financial services for a markup. So thank you for the privilege of testifying. And he will tell a horrifying story. Unfortunately, several of his colleagues in the business are no longer in business because they just simply didn't survive what he's gone through. Thank you.
Thank you, Mr. Bacchus. And Mr. Magnus, thank you for appearing here today, and we appreciate you and look forward to your testimony.
Thank you, Chairman Tipton. Thank you, Representative Bacchus, for your words and your friendship. I'm testifying today to explain the constant struggles small and medium-sized manufacturers face with unfair trade. In 2002, my company, along with 2 other U.S. hanger producers, saw a flood of Chinese-made hangers entering the United States at below our cost. We decided to file a Section 421 trade case, which is one avenue for relief for U.S. producers that are being harmed by imports from China. We were successful in our trade case at the ITC, but unlike an anti-dumping or countervailing duty case, a Section 421 case has to go to the President for approval. Unfortunately, no relief was granted. Shortly after that, Cleaners Hanger Company, an American company which was the largest garment hanger producer in the world, filed for Chapter 7 bankruptcy. Then it seemed like dominoes. All of the remaining U.S. hanger producers, with the exception of M&B, either went out of business or closed their U.S. operations and imported all their hangers from China. Over the next few years, we struggled, having to close our plant in South Hill, Virginia, and lay off 85 hardworking Americans. We continued our struggle, but the Chinese were relentless. And eventually, we had to either import 100% of our hangers or fight by filing an anti-dumping petition against China. We chose to fight. On July 31st, 2007, we filed an anti-dumping petition against Chinese hangers. When we filed, we were almost out of business, and we really didn't know how we were going to pay the substantial legal fees and other costs to file this case, but we proceeded. After a long and demanding process before the ITC and Commerce, dumping duties ranging from 16 to 187% were imposed on imported hangers from China. Things improved, and we were able to pass along raw material increases. But just as we were hiring again, increasing our production, the same producers that were shipping hangers from China were working on illegal schemes to avoid dumping duties by shipping their hangers through other countries, or simply just changing the country of origin on the paperwork. We filed over 30 Eallegations with Customs with specific information about these illegal schemes. We met with Customs officials on a number of times detailing what was happening, but we saw no progress. We then hired an investigator at great cost to our small company and sent him to Taiwan and Vietnam to visit these so-called new factories that were shipping hundreds of millions of hangers to the United States. He didn't find any hanger factories, but he did receive detailed offers from Chinese producers to illegally transship hangers to the United States through Taiwan and Vietnam, avoiding the dumping duties that should have been collected. When our investigator returned, we took him, his reports, and our attorneys and met with Customs as well as Immigrations and Customs Enforcement, or ICE, to detail the schemes. I felt really good when we left the meeting. But with the exception of one small importer transshipping Chinese hangers through Mexico, nothing happened. We then filed anti-circumvention petitions against 2 so-called hanger producers in Vietnam. We won those cases too. But with the help of the Chinese producers, hanger imports from Taiwan and Vietnam continued to grow. We had no choice but to file an anti-dumping case against Taiwan and anti-dumping and countervailing duty cases against Vietnam. We won those cases as well, but immediately hangers started appearing from Laos and Malaysia. We have been told these hangers are made in Vietnam or China and transshipped to the United States. We decided not to file any more Eallegations or send investigators to these countries to bring back proof of duty evasion because we saw no results from our previous efforts. M&B, along with U.S. producers suffering from the same evasion schemes, formed a coalition to try to get meaningful legislation passed to address these illegal activities. The Enforcing Orders and Reducing Custom Invasion, or Enforce Act, creates a procedure at Customs to investigate claims of evasion, including timelines for Customs to make determinations and apply the appropriate duties, as well as regular and timely reports that will not only deter future evasion, but add transparency, accountability, and oversight where there currently is none. The provisions of Enforce passed the Senate Finance Committee by voice vote and have been included in the Senate reauthorization bill, Customs reauthorization bill. The complementary bill in the House, introduced by Representatives Long and Sanchez, has a bipartisan group of 46 co-sponsors. There are many other industries that face the same struggles with cheating, illegal transshipping, and evasion of their orders. They include industries making nails, inner springs, threaded rod, PC strand, wire shelving, and many more. We all produce with a high degree of integrity, which includes paying our workers a fair wage with good benefits, being environmentally responsible, paying taxes, and providing return on investments. Without meaningful relief from ongoing duty evasion schemes, it will be difficult to maintain our U.S. production. Thank you for your time, and I'll welcome any questions.
Thank you, Mr. Magnus. Our next witness is Mr. Peter Jones. He serves as legal advisor to Spyderco, a manufacturer of utility knives based in Golden, Colorado. Spyderco is a family-owned enterprise started in 1981 and currently exports its products to over 60 countries. Mr. Jones, thank you for appearing here today, and we look forward to your testimony. Please begin.
Thank you. Chairman Tipton, Ranking Member Murphy, members of the subcommittee, thank you for your invitation to appear today. I'm Peter Jones, Manager of Research and Development at Spyderco Incorporated. The company's designed and manufactured and distributed some of the highest quality and most innovative folding knives and related products in the world. Spyderco was built from nothing by its founder, Sal Glesser, and his family. It now employs more than 80 individuals in Golden, Colorado, generates $20 million annually, and has been awarded more than 190 pieces of intellectual property worldwide. Customers have come to rely upon the high performance, superior engineering, and ergonomic designs of Spyderco's products. These customers include virtually all of this country's military branches, special services, law enforcement personnel, and are in service at every level of state and local law enforcement. We sell our products through the United States and to 57 countries around the world. A significant portion of our manufacturing is performed in Golden, and we're in the process of tripling that capacity. The safety and reliability of the tools used by our country's servants should not be called into question. However, that is exactly what is now happening. An alarming increase in counterfeits, knockoffs, and infringing product is flooding the United States market by Chinese companies. The Chinese counterfeits are anything but an exact duplicate of the genuine item. These products are made of inferior materials, demonstrate poor manufacturing techniques, making for a dangerous and unreliable tool for service personnel and the consumer alike. These copies have achieved a level of outward appearance that makes it difficult for even our own staff to tell a genuine product from a fake. Spyderco does its best to police the marketplace, seeking to remove copies from the stream of commerce. For the most part, Spyderco has been successful in these activities, stemming the flow of counterfeit goods being sold through the United States sales entities. However, it is having difficulty stopping the sales of counterfeit products sold through Chinese distribution outlets. Indeed, the bulk of these copies are entering the stream of commerce through online auction sites, primarily Alibaba, Taobao, and DHgate. These Chinese-owned sites have a very poor or no response to requests to remove auctions of infringing goods. In contrast, the famous online auction house eBay has developed their verified rights owner program to combat just this issue. Although utilizing more of a storefront format, Amazon.com also keeps a tight rein on infringing products, preventing their entrance into the Amazon.com stream of commerce. Costs associated with trying to remove unauthentic products from Chinese sales websites is now prohibitive. As with all small business operations, availability of funds to find an infringement war are restricted. Every dollar diverted for an effort to protect the marketplace from unsafe counterfeits and patent infringements takes money from corporate activities such as research and development, increasing production capacity, additional employees, machinery acquisition, wage increases, etc. As a result, copies of many of our core products are now available on these sites at significantly lower prices than for which our genuine products can be offered. As I'm sure we all realize, it is impractical for U.S. Customs and Border Patrol to inspect every package coming into this country. If all manufacturers selling products in America, domestic and international alike, were subject to the same intellectual property enforcement standards, this problem would be alleviated. All Internet auction sites should be required to have an infringement notification and removal system that works. This would level the playing field between the U.S. and Chinese-owned Internet auction and commerce sites. It would also provide an ideal point for IP holders to review and stop the offer for sale of infringing items being put into commerce worldwide. Spyderco agrees it's important for the United States to continue embracing free trade principles with our trading partners. However, it is imperative that these partners respect and enforce American intellectual property rights regardless of importation venue. Spyderco respectfully requests this subcommittee and the United States Congress to implement laws and treaties which require all websites viewable within the United States to publish and enforce strong intellectual property protection mechanisms, and to require trading partners to respect and enforce American intellectual property rights. Thank you.
Thank you, Mr. Jones. Good to see a fellow Coloradoan here, and it's now a pleasure of mine also to be able to introduce another fellow Coloradoan and also a constituent of mine. Has a product that I think it's important for any of us who like to be able to eat in this country, representing a lot of our farm and ranch communities and in terms of his property in Alamosa, Colorado. Our next witness is Mr. Don Shakroff. He is owner of John B. Shakroff Ranches in Alamosa, Colorado. If you haven't been there, one of the most beautiful places in the country and certainly an invite a visit. In addition to operating a small cattle operation, Mr. Shakroff also serves as president of the Colorado Farm Bureau and been a great advocate on behalf of our farm and ranch community, and appreciate you taking the time to be able to be here today to testify. And please continue.
Thank you, Chairman Tipton. Members of the subcommittee, thank you for holding this hearing. I am Don Shakroff, president of Colorado Farm Bureau, a fourth-generation rancher from the San Luis Valley of southern Colorado, and a board member of the American Farm Bureau Federation. Farm Bureau is, in fact, the largest agricultural-based grassroots organization in the country, with a membership of over 6 million farm and ranch families, growing everything imaginable, from alligators to children to grandchildren and even to zucchini. Trade is vitally important to agriculture and the U.S. economy. According to USDA's Economic Research Service, the $136.4 billion of agricultural exports in 2011 produced an additional $176 billion of economic activity in the United States, including 637,000 jobs in the non-farm sector. Ag exports help offset some of the non-agricultural U.S. trade deficit and are a significant market for ag products from Colorado and the rest of the nation. Agricultural trade could and will be more significant if and when it is unfounded upon SPS issues and non-tariff trade barriers. These things are eliminated. For example, Mexico has been using sanitary and phytosanitary measures to block the importation of U.S. potatoes into Mexico cities beyond those cities that are near our common border, where we have been able to in the past. However, I am pleased to announce that through the hard work of negotiation, now, over time, Colorado potatoes will be allowed into Mexican cities and with populations of 100,000 or more. Early estimates give the indication that revenue from potatoes could be as high as $80 million, a truly four-fold increase over the present situation. This is a prime example of how SPS issues are used to prevent agricultural trade, and how they can be overcome with science and negotiation, and have a direct impact on American farmers. I ask you today to do all you can to eliminate all SPS issues and other barriers to agricultural trade. As was mentioned, when it comes to trade, currently there are 3 T's that are in action and things that can be done. One is the TTIP, or Transatlantic Trade and Investment Partnership Agreement. The other is the TPP, Trans-Pacific Partnership Agreement. And the other is key as well, Trade Promotion Authority. The TTIP negotiations between the U.S. and the European Union are an opportunity to deal with many substantial issues that impede U.S. and EU trade in agriculture, such as long-standing barriers against conventionally raised U.S. beef, ongoing restrictions against U.S. poultry and pork, and actions that limit U.S. export of goods produced using biotechnology. The U.S. and the EU are major international trading partners in agriculture. 10 years ago, the EU was the 3rd largest destination for U.S. ag products, but over the last decade, this growth has been the slowest among our top 10 agricultural destinations. The EU is now 5th largest export, and in 2013, we exported to them $11.5 billion of agricultural and food products, while they exported to us $17 billion of ag products. This market needs to be increased, and the TTIP is an opportunity to do so. The other trade agreement, the TPP, deals with, of course, Pacific countries. And in particular, one of those important ones is Japan. Japan is currently the 4th largest export market for the United States, with over $14 billion of trade. This is important because Japan continues to do things that restrict the trade based on SPS as well as non-tariff barriers. The tariffs going into Japan need to be reduced. That is something that can be done with this agreement, and hopefully that will in fact happen. The last and perhaps the most important thing is the Trade Promotion Authority. If we negotiate these other agreements and the Trade Promotion Authority is not available to quickly and effectively put a stamp of approval by Congress on these agreements, much of that effort can be wasted. I highly encourage you to support the current Trade Priorities Act of 2014, which is H.R. 3830. It is a necessary and critical component for a successful trade policy agenda. While there are many challenges that yet remain, I again thank you, Chairman Tipton, and members of this subcommittee for the opportunity to testify to you today of this important issue. American agriculture drastically needs more market access that is free of SPS and non-tariff trade barriers. American farmers and ranchers are the most productive in the world. With market access, we can continue to provide high-quality products to markets throughout the world. I look forward to answering any questions you may have. Again, thank you.
Don, thank you for your testimony, and I'd now like to be able to yield to my colleague, Ms. Ming, for purposes of introduction of our final witness.
Thank you, Mr. Chairman. It is my pleasure to introduce Tim Brightbill. Mr. Brightbill is a partner in the international trade practice of Wiley Ryan LLP in Washington, D.C., where he represents clients on all aspects of international trade law and policy, including import trade remedies, global trade policy, and trade negotiations. He is also an adjunct professor at Georgetown University Law Center and has provided advice to the U.S. government on ongoing trade agreement negotiations, such as the Trans-Pacific Partnership and the Transatlantic Trade and Investment Partnership. He is a graduate of Northwestern University and Georgetown University Law Center. From 1994 to 1995, he served as counsel to the House Committee on Small Business. Welcome back, Mr. Brightbill.
Thank you, Congresswoman. I appreciate that. Chairman Tipton, Ranking Member Murphy, members of the subcommittee, thank you for the opportunity to testify before you today on the issue of unfair trade practices and barriers facing small business exporters. I've practiced international trade law for almost 20 years, and my practice has always focused on helping American companies, American industries, and American workers. I've worked with a variety of industries, including manufacturing of everything from steel to solar panels to school notebooks to heavy forged hand tools. I also work with many companies that provide services, both here and abroad. My job is to help these companies grow, prevent unfair trade practices from harming them, and to help eliminate trade barriers overseas. Small businesses face enormous challenges in the area of international trade. Trade laws and regulations are complicated. Trade remedy cases are expensive, as you've heard, and trade barriers are becoming more pervasive and more challenging all the time. As a result, it is probably not surprising how few small businesses are able to become substantial exporters of goods or services. Let me list several of the challenges facing U.S. small business exporters. First, dumping and subsidies. These are two of the most pervasive unfair trade practices. Foreign manufacturers often sell below cost to enter the U.S. market and take market share away from domestic competitors. Subsidies and government ownership of foreign competitors facilitate this kind of unfair pricing. Small businesses are forced to choose between cutting prices to match foreign competition or giving up sales and market share. Notably, the anti-dumping and countervailing duty laws that address these practices are complex, and the requirements for filing trade remedy cases are difficult even for large companies. There are many steps that Congress and the Commerce Department could take to make the trade laws simpler and easier to use for small businesses. I'd be happy to discuss those specific ideas later this morning. Also like to endorse the comments of Mr. Magnus regarding the Enforce Act, which we hope will be passed and signed into law this year. Second is currency manipulation. This is a serious problem that harms all U.S. exporting businesses, large and small. The Peterson Institute for International Economics has called currency manipulation the biggest subsidy of them all, and estimates that currency actions by China and more than 20 other countries have increased the U.S. trade deficit by $200 billion to $500 billion per year, and that the United States has lost 1 million to 5 million jobs as a result of foreign currency manipulation. If Congress wanted to take one trade-related action that would create new American jobs, it would be to pass legislation to investigate currency manipulation as a countervailable subsidy. Third is intellectual property theft. This is a pervasive problem, demands a serious response from the U.S. government and law enforcement. The United States took an important step this week by filing criminal charges against the Chinese military for cyber hacking. The U.S. companies targeted are at the heart of American manufacturing of steel, aluminum, solar, and others. And I applaud the administration for taking that step. But the reality is that the Chinese government sees no difference between military espionage and corporate IP and trade secret theft. And there are thousands of U.S. companies that are victims of these activities. As one expert has stated, there are two kinds of U.S. companies, those that know they've been hacked and those that just haven't figured it out yet. Fourth is the rise of state-owned and state-controlled enterprises, another factor that is very harmful to small business exporters. U.S. companies should not be forced to compete with foreign governments. And while China is a big problem in this area, there are many other economies that are problems as well. We need to include strong, enforceable disciplines on state-owned enterprises in all new trade agreements, including the TPP and the TTIP agreement. I'd be happy to discuss that later today as well. Finally, we need to address the growing use of non-tariff barriers to shut down trade. This can involve obvious measures like export taxes, but also more subtle barriers like customs regulations, import licenses, and burdensome standards and certification requirements, even SPS requirements, as Mr. Shakroff just noted. The United States has been very successful in reducing tariffs worldwide, but those that want to protect their markets are continually looking for new ways to shut out foreign competition. So thank you again to the committee and the subcommittee for addressing this important issue today, and I'd be happy to answer any questions.
Well, thank you all for your testimony here this morning, and appreciate you again taking the time to be able to be here. I'd like to begin some of our questioning, and Mr. Shakroff, I'll like to be able to begin with you. A number of nations have imposed trade restrictions on GMO crops, citing safety concerns. Do you believe science supports these claims, or some of our trading partners claiming safety is a dubious excuse to be able to limit the export of American products?
I think you have stated the problem precisely. The science does not back up these claims. In fact, just the opposite. Science proves that these GMO products are safe. They have been through a rigorous testing. And it goes back to a precautionary type of approach that, in particular, the EU takes upon these things, and that is that it's trying to prove the negative. If there is no evidence that, in fact, they do not cause this, instead of saying, well, this use of this product does cause X, Y, and Z, if you do not have the proof that it does not cause those kinds of things, that's a precautionary principle, and that's, I think, true in the GMO case as well as other things that the EU is concerned about. We're extremely about the GMO case because there is a tremendous opportunity for increased corn and soybean export to the EU, and that's an important issue.
Well, I appreciate that. And while we're on some issues for the San Luis Valley, you mentioned how potato growers were able to successfully challenge unfair Mexican SPS standards that restricted American potato exports. In this case, is it an outlier, or is the WTO dispute resolution mechanisms, are those adequate to be able to address agricultural product barriers in a timely manner?
I think that it is an effective avenue, but it does take time and it does take money, just the same as the other issues that have been discussed here by the other witnesses. The cost is tremendous, and I applaud Mr. Magnus for going through the effort of challenging those things rather than just lying down and going on his own way and doing something else. WTO is a process. We need to support that process. We need to make it something that is workable in a more expeditious manner, just the same as TTIP and TPP need to have those types of provisions where action can be taken and that they can be enforced, and again, in a timely and effective manner.
Yeah. Do you believe that some of the future multilateral trade agreements, such as the proposed TPP and TTIP, should adopt similar SPS resolution mechanisms?
I believe they need to. If they were to follow the lead of the WTO and say that those SPS issues can only be resolved based on science, and that they need to have a level of reasonability to their implication and implementation, I think that's important.
You know, and I think you brought up an important point. Mr. Magnus, how much money did you spend in terms of trying to be able to defend yourself?
Enormous amount. It's an ongoing process. We have to go through administrative reviews every year, and that is expensive. Also, it's well over $1 million to file a trade case, and then it's $250,000 just to maintain them.
This out of your pocket?
The government doesn't pay for it. Yes, sir. It's out of my pocket.
It's out of your pocket.
Whose other pocket?
Bottom line, either way, you're paying for it, even if the government pays for it. So,
yes, sir.
Still got that challenge. Mr. Jones, appreciate you taking the time to be able to be here, and a lot of great opportunities, certainly for small businesses like mine, to be able to take advantage of the websites and to be able to reach out of our different areas to be able to sell some of our products. But it also appears that it is, as you noted in your testimony, ripe with opportunities to be able to counterfeit some of these products. eBay has its verified owner rights program in place to be able to prevent these counterfeits, but many other foreign websites, as I know you're aware, do not. Right. What actions do you believe that the government should take to be able to prevent websites from carrying counterfeit products?
Well, we have found the huge bulk of our patent infringements coming in over Chinese websites, auction sites. And what we'd like to see is just to have the same expectations of those websites as far as being able to have an infringing product taken off of it. The sale of an infringing product, eBay responds to us now within 8 hours to have, if we notify them of an infringement that's being sold on the as an auction. Alibaba, we almost don't get any response. Alibaba, DHgate will make us prove our IP rights to an item that's on sale on their website, whereas eBay, they will just allow us to say we'll take liability for the case if we say we have these pieces of intellectual property and we're willing to sign off on the liability issue for eBay. eBay will respond to us right away and does so. They're quite good about that.
You know, I'm curious, Mr. Jones, have you been able to do any sort of an estimate in terms of what you've lost in terms of counterfeiting?
We had that discussion just before I came here. Our financial losses are probably not what would be considered to be significant. Where we really have concerns is with losses with our reputation. For example, a customer will buy a product off of a Chinese website or a secondary sale that's occurred from a product that we know came in through a Chinese website but was sold, for example, at a store or flea market or a secondary sale. And then they're calling us saying, what's your customer service going to do for this? It's broken, it's wounded me, it's fallen apart, it's a poor product. And then our reputation winds up on the line because we have to tell that person that's not our product. It's a clone. We're aware those are out there. We apologize. We're working to cure that market, to close that market up, but that's not our product. And you can imagine that creates quite a bit of animosity in the customer business relationship.
I can imagine. I don't want to belabor this, but I'm a little curious, given what you just commented, where somebody wounds themselves.
Well,
have you had the threat of a lawsuit when it wasn't your product?
Well, no, because it's not our product. We're not in the chain of liability. But of course, we still have concern for the consumer. We have concern for people that thought that they bought our product. We have a high-end product. As I mentioned, a lot of our products find their way into service in this country, in law enforcement, and in all of our country's servants. And we're really quite concerned that some of those people are going to get a hold of inferior product, and they're not going to meet the standards and the expectations that they have.
Right. We appreciate that. Mr. Brightbill, certainly hearing some of these comments, I wouldn't ask you, though, they'd probably appreciate it to be able to provide some free legal counsel on some of these issues. But what is the first thing that you would tell a small business company like Spyderco or M&B Metal Products if they came to you asking for help with intellectual property theft and dumping?
Well, I think there are a range of options available. It's true that the trade remedy cases are very expensive. They can be time-consuming. There are other ways to address the problem, sometimes in negotiations, although that can be difficult. There was the reference to negotiations with Mexico. There are agencies that are out there willing to put some effort in, whether it's Customs and Border Protection, Commerce Department, the U.S. Trade Representative. We've had good results sometimes just on a bilateral level, talking to another country, flagging a barrier that they've imposed without having to bring a full case. So although sometimes trade remedy cases are necessary, there are other ways sometimes to address the same problem and hopefully get some results for companies that shouldn't have to pay for this, and the government can support them on it.
Okay, I appreciate that. Mr. Magnus, I thought it was curious in your testimony to where you were able to stop the legal importation through legal remedy and awareness, but then it would pop up coming out of a different country as well. And it kind of reeked of whack-a-mole. You put one down, another one would pop up somewhere else. You reference that transshipping way as a way that they're using to be able to avoid the tariffs and trade laws. And do you have some recommendations that you could make to Congress on how to best and most effectively combat that?
We do, and we have, in the Enforce Act. The Enforce Act sets timelines, makes accountability where there is none, and involves the private sector as well as Customs. It's a tough job for Customs, but it's a black hole when we give them something because we never hear back from them. But we've detailed it with the Enforce Act. Senator Wyden endorsed it, and his staffers even in a half a day were able to set up illegal transshipping schemes from China on hangars. He called, they emailed the Chinese producers and say, yes, we can't ship it from China, but we can ship it from another country, and this is your price. They don't respect our trade laws, and the provisions of the Enforce Act that we've put before both the Senate and the House details some steps to be taken.
Yeah, I'm certainly aware of the Enforce Act. Do any of you other gentlemen, do you have any other comments or thoughts in terms of how Congress can start to be pushing back to make sure that our businesses, our jobs are going to be able to be protected?
I would suggest that the principle of trust but verify is a very important aspect in all of these negotiations. As was mentioned, referred to the Mexico situation in potatoes, that took a long time. It was a slow process. And now what has to happen is we have to, in fact, trust those Mexican officials and what they've said they will do, but follow through and make sure that they, in fact, do that. I think that's an important aspect.
Great. Gentleman. Mr. Brightbill?
Sure. Just with regard to Mexico, I wanted to point out that a couple of industries we work with, notably the steel industry, is facing a similar problem where Mexico has introduced a new import licensing system that is holding up steel shipments at the border and greatly increasing costs for U.S. companies that are trying to export, large companies and small companies. And then just to highlight the Enforce Act one more time, we've had a couple of cases as well where the circumvention begins even before the trade case is over. We've brought cases on school notebooks from China. Before you know it, they're allegedly coming from Taiwan or some other country. Another case we brought on steel grading, subway grading, like you walk on here in Washington. Before the case had even ended, all the exports from China had disappeared and they started showing up from Malaysia. The only problem is Malaysia doesn't make bar grading. So this is the kind of problem that companies face every day. And while Customs might bring a big enforcement action after 4 or 5 years, what we really need is enforcement of the anti-dumping duties right from the start, and that's where the Enforce Act could really be valuable to companies and industries like ours. Great.
Well, appreciate, again, gentlemen, your comments. I'd now like to yield to my colleague, Ms. Ming, for her questions.
Thank you. I have a question for Mr. Brightbill. Trade assistance is administered by 20 different federal agencies, each of which is tasked with their own mission. their own set of policies, and their own competing resources. What, in your opinion, would be the quickest and most cost-effective means of improving coordination between these agencies and harmonizing their export strategies? And anyone's free to answer.
Well, thank you for that question. I think this committee and subcommittee have done a good job flagging the issue that there are lots of resources out there, but they overlap, and the missions are not always clear to companies out there just trying to figure out, how do I send my products abroad to other countries? So I think there is a way to streamline and simplify and try to not have so many different agencies trying to provide aid, so that it's understandable to the companies who aren't familiar with all of these different programs and efforts. So I think this committee has done a good job flagging that as a place to start.
And we frequently hear that small businesses make up 9 out of every 10 businesses that export goods from the U.S., but when it comes to the negotiating process for these trade agreements, the interest of the small business community often takes a back seat to that of the larger multinational corporations. Is there anything that can be done to elevate the concerns of these small businesses in ongoing multilateral trade negotiations?
I would just say to that there is a system of industry trade advisory committees that provide input to the trade negotiators. I sit on one of those committees relating to services, and there is a specific small business committee that is open. Now, that is one way that some of the views can get across, but I do think the process needs to be more transparent. We're negotiating very significant gold standard free trade agreements. I think if the American public and American businesses knew a little more of what was being negotiated, they would support them strongly, and they would be enacted into law once we reach these final agreements. But in the meantime, when the process is not particularly transparent, it's very difficult to build support for them.
Yes.
Yes, thank you. I would also like to also comment the value of, in behalf of small businesses in agriculture, organizations like the American Farm Bureau and Colorado Farm Bureau who stand up for the needs of those individuals and those small businesses in those negotiations. That type of representation is important.
Thank you. And as the U.S. continues to negotiate with its 11 partner nations on the terms of the TPP trade agreement, as you know, the administration has been less than forthcoming with specifics. With trade talks resuming this week, what protections are vital for your industries in any new agreement with Pacific Rim countries?
Yes, thank you. I would just say that foremost is the concerns that have been expressed here today. The idea of having provisions there that the anti-dumping cannot happen, and make sure that those countervailing issues are resolved, and particularly for agriculture, the non-tariff trade barriers and the tariff barriers, the SPS, sanitary and phytosanitary issues in agriculture. Those types of things need to be in that agreement specifically, and that there needs to be a viable and easily accessed enforcement tool in those agreements.
Congresswoman, I'd just add to that, the issue of state-owned enterprises is a critical one. We have not had SOE provisions in a free trade agreement before. We need strong enforceable disciplines there. Companies should not have to compete with foreign governments, and they shouldn't have to compete with foreign government investments, whether or not it's coming here or in a third country. And so we need strong enforceable disciplines. State-owned enterprises should not receive preferential legal or regulatory treatment. They shouldn't receive subsidies. And we should have a way to be able to ask questions of these state-owned enterprises and get information. That's the least we can do in a free trade agreement like the TPP or the TTIP.
If the TPP is ratified, would U.S. beef producers create more jobs as a result of it, or would the benefits flow mainly to foreign producers?
I would certainly expect that in agriculture, in particular beef, that the advantage would be to us. There is much of the beef production today that goes internationally because, quite frankly, most American consumers are not interested in consuming that part of the animal, as well as particularly the impact of the high-end cuts when it comes to steaks and prime rib roasts and those types of things in the beef trade. that demand is in fact global, and so those products move across the world. The more demand that there is with growing economies and emerging economies around the world, I can see that I would certainly hope at least and believe, in fact, that those prices would increase because of this agreement once it were ratified by Congress.
Question for Mr. Magnus, or again, anyone is welcome. When I talk to small firms in my district, the barrier they most commonly raise is not necessarily stiff tariffs on exports, but finding affordable credit to support their export business. Do you believe that the government's current mix of trade financing programs meets the needs of small firms?
I will have to decline answering that. I am not fully versed on that. Most of our trade issues are dumping coming this way, not being able to ship, export, because many other nations don't have dumping duties on Chinese hangers. It's very difficult for us to compete in foreign countries because of the low-priced Chinese hangers in foreign countries.
On the financing issue, there are financing programs available through the government. I think this committee has emphasized private investment and private financing as well, which is important. One concern we have is when Exim Bank provides financing abroad in areas where there's already overcapacity, like steel or raw materials that then goes into steel coming back here. So that is a particular concern, where the financing is subsidizing or benefiting excess capacity abroad that then is going to come back here and compete with U.S. companies. So, but in general, I think there are financing options available. It's still difficult for companies and small businesses in particular to get credit. Many of my clients, which are in a weakened condition when they're bringing these dumping cases, also have difficulty in terms of financing and credit to grow their businesses. So that's still an important area of concern.
Thank you. I yield back, Mr. Chairman.
Yeah, and I appreciate the question, particularly on some of the access to capital issues. We've got a bill that I'm co-sponsoring called Capital Access to Main Street to be able to actually allow banks, eliminate some of the regulatory requirements to be able to do a look back on 7 years of financial statements, P&Ls, balance sheets, to be able to make a good business decision. When we talk about our farm and ranch community, the crops can be flooded out, frozen, or burned, but in that 4th year when the commodity prices are up, it's going to come back. We just need to be able to free up some of those banking options and let bankers be bankers, I think, frankly, to be able to address some of that. I did, since we've got just a couple of minutes, I think, before votes are going to be called, Mr. Magnus, your company has filed more than 30 Eallegations with the Customs Service once you discovered that Chinese manufacturers were circumventing the anti-dumping duties. What kind of response did you receive from the agency?
We received none, except when we would meet with them, they would say that we received your Eallegations, but because of the laws, we cannot report on what we're doing on them. So they really, once you file an Eallegation, you have no idea whether they look at it, whether they act on it, or whether they throw it in the trash can.
So the answer is nothing.
Nothing.
Absolutely nothing.
Absolutely nothing.
Yeah. Would you remind me again how many Americans you employ?
In Alabama, we employ between 80 and 90. Okay.
Great. Well, that's some good information for us. And Mr. Jones, has your company attempted to be able to avail itself of any of the intellectual property remedies through the ITC? And have you been made aware of some remedies that are potentially available to you?
We pretty much fairly recently come aware of the ITC. We have quite a cyclical sales. 4th quarter is quite high for us. If we were to request Customs to stop a shipment of infringing product and they were to stop one of our shipments, remembering that these are clones, that could very well put Spyderco out of business. It's a very large concern with us, and we've had some of the same responses to our concerns with Customs that Mr. Magnus has had. We don't see, we haven't had a lot of response. We've had quite frankly, rumors and competitors in our industry discuss the same problem, and they feel like Customs is somewhat unresponsive to them. We have a large fear that if we were to request assistance there, that some of our stuff would get stopped and we wouldn't have the ability to continue business, basically. Our American production will not support us at this time, although we're trying to get that ramped up. So it's a bit of a fearsome situation.
So you aren't feeling a lot of support in that area?
No, sorry.
Okay. No, that's good for us, actually, to be able to know. You know, it took this administration more than 2 years to be able to submit the Korea, Panama, and Colombia free trade agreements to the Congress. And during that period of time, these nations that just sided had ratified trade agreements with other nations, resulting in American farmers losing a substantial market share to their competitors. Mr. Shakroff, do we need to be able to guard against something similar happening while we negotiate this Trans-Pacific Partnership and the Transatlantic Agreements?
We do. I'm not real sure what you can do to keep other people from taking advantage of an opportunity other than to move quicker, and in fact for Congress to take action and promote and approve a trade promotion agreement, so that once those negotiations have taken place, it can be ratified quickly without a lot of discussion about what the individual terms of it are. I know it's sometimes somewhat perceived as a two-edged sword when you have a trade promotion authority, because not everybody will be happy with it, but it's something that we have to rely on those negotiators. And if there's a little bit of emphasis that it needs to be done quickly by Congress, and example yourselves in this subcommittee, who can influence the expeditiousness of that, I think it needs to be done.
Well, thank you. And gentlemen, I'd like to thank you all once again for taking the time. Ms. Ming, did you have any other further questions to follow up on? Want to thank you for taking the time to be able to be here. This has provided us with some good information in terms of the responsiveness and lack thereof by the government in terms of being able to protect American jobs and to be able to expand those opportunities to create more jobs. Here, I know in our district, that's the #1 issue, jobs in the economy that people are concerned about. And our opportunities to be able to export, we have the empirical evidence when those are present, and we have the opportunity to be able to do it in a fair way. We actually benefit the American consumer and certainly American families in that process. You've all provided some very important insight to that and how unfair foreign trade practices are actually impacting our small businesses. This insight will assist us in Congress in our efforts to be able to ensure that foreign nations and companies play by the rules so that we're going to be able to compete on a level playing field, which is, I think, all that we ask for. I would like to be able to ask for unanimous consent that members and the public have 5 legislative days to be able to submit comments and supporting materials into the hearing record. Hearing no objection, so ordered. And this hearing is now adjourned. Thank you again, gentlemen, for your time.